Sometimes it's frustrating to know that objections are being made and certain evidence or information, anyway, is being hidden from the jury. And a lot of times when you're watching, it's hard to tell exactly what's going on. Some of that happened with Dr. Ann Shufflebarger, and I want to explain a little bit about that. Here's what we're talking about today. We're back in the Abby Zwermer case today, and again, I need to go through a little bit of the backstory so some of the testimony today will make more sense. On January 6, 2023, while teaching first grade at Rich Neck Elementary School in Virginia, Ms. Zwermer was shot by a 6-year-old student who brought a 9mm semi automatic pistol to the school. The bullet first passed through her left hand, rupturing bones in her index finger and thumb. Then the bullet entered her chest, and some fragments remain lodged there between her heart and her spine. Her lung collapsed as a result of the chest wound. Authorities described her injuries as life-threatening initially. One of the things about evidence is that you have to have the evidence conform to the rule of law. And if it doesn't conform to the rule of law, obviously it is objectionable. In this case, the school had a handbook and policies related to dangerous weapons. There were things that their handbook required them to do. And every time the handbook here gets mentioned, the defense jumps up like a jack in the box and objects because it's not the standard of care. And you would think, well, how ridiculous is that if they're going to lay out what they want these people to do and they don't do it? How is it not the standard of care? Well, it's not the standard of care because Virginia case law says that it's not the standard of care. In Virginia, the general rule is that an organization's internal policies and procedures do not themselves determine the legal standard of care in a negligence or a malpractice action. Now, malpractice is governed by statutory rules that are not important here, but common law covers the rest. Instead, the standard in common law is what is a reasonably prudent actor or professional in the same field, what would they do under the circumstances? In law school, I heard it stated as the standard of care is what a reasonably prudent practitioner in the same or similar circumstances would do in that circumstance. So, the reason it's broadly stated like same or similar circumstances is because it doesn't matter, for example, in this case, what the weapon is, whether it's brass knuckles or a knife or a pistol. The standard is if it's a weapon, if it could hurt someone, you have to take action. Because if someone sees it, if somebody reports it to a teacher, which is, of course, what students are told to do, then you have to follow the protocol. And the protocol is that they let the principal know that they have this issue. And of course, the standard of care in this case, the Zwermer case, is what would a reasonably prudent practitioner, in this case, a school principal, do in the same circumstances with this case if somebody came to them and told them that they had a gun? Well, that was the reason why they called Dr. Ann Shufflebarger, because she was in that same field. She had done that job, and she'd done it in Virginia. She had her doctorate in education, and she could explain to the jury what the standard was. At least that's the way it's supposed to work. Virginia requires that there be a pretrial expert report and that you can't go outside the expert report. And apparently, the handbook did not get to her before the discovery period closed, so she couldn't use the handbook in saying that that's the standard of care. And of course, it's not the standard of care, and I'll explain that more in a minute. But she couldn't rely on it because it wasn't produced or introduced in the pretrial discovery. I'm not quite sure how the plaintiffs got it, but they got a copy of it, and as a result, they attempted to use it, and they've not been successful. although the judge has allowed them to use it and use pages from it to examine certain witnesses. So, why does this rule exist? Well, like I said, in general negligence, non medical cases, Virginia courts apply the common law duty of ordinary care. In other words, what would a reasonably prudent person do under the same or similar circumstances? Well, here's why internal policies and procedures, that handbook, the staff handbook, by itself can't set the standard of care. Virginia courts have held that private rules, for example, internal policies, training manuals, company safety regulations, cannot be used as the standard of care because the standard of care is fixed by law. In a malpractice action, it's by statute, and in common law, it is the duty of ordinary care. It is not what a defendant chooses to adopt internally. In other words, a party cannot decide its duty to others by promulgating rules of its own. And the reason comes from a case called Pullen versus Nickens, 226 Virginia 342. It's a 1983 case. In that case, the court said a person cannot, by the adoption of private rules, fix the standard of his duty to others. In other words, he can't set it lower or higher than the law requires. And the rationale is that if an internal rule could determine the duty, companies might adopt minimal rules to shield themselves. For example, if a student comes to a teacher and says, "Mrs. Jones, I think Johnny has a pistol or a knife or brass knuckles or whatever. And that's a weapon and it really scares me." The handbook could say, if you believe Susie is really scared, you can notify the administration, but you're not required to. So then, later on, he reaches into his pocket, takes out his brass knuckles, and bashes Susie upside the head, and now you've got a lawsuit. Well, a lawsuit, if you used the school's standard of care, they would meet that standard of care. And of course, that's what they are trying to avoid, because that is not ordinary care. And in this situation, the standard of care is that of reasonably prudent practitioner. Now, in this case, at least according to the opening by the defense, they have to show more than just simple negligence. They have to show essentially acting with complete disregard, that sort of thing. I'm not sure that's absolutely accurate, but we'll take it for what it's worth in this case. So, in that case, they have to show something a little bit beyond what is negligence. And again, you can't use the internal policies to set that standard of care. You have to find it in the common law, and in this case, that means you have to go get an expert to give you that information. And it's also worth noting that a company's private rules can't be used against it to set the standard of duty to others, but they can inform the question. Because although internal policies can't by themselves define the standard of care, they can still play an important role. One of the things that the plaintiff has to prove is evidence of notice. In other words, that there was evidence of a duty, that they should have knowledge of what they were required to do. So this shows notice to the principal, to the assistant principal, of what is required of her by school policy. And as a result, it can show foreseeability. It was foreseeable that someone would bring a weapon into a school because ever since Columbine, that's been happening. It notes foreseeability and the district's recognition of that foreseeability, irrespective of whether this particular individual could foresee it or not. It also shows knowledge of hazard, or it shows training, how people are taught to deal with a particular hazard. Internal safety rules or training materials may be relevant to show that a defendant knew or should have known about a hazard or risk of harm. Well, obviously, they should have known from knowledge that there is a gun on the premises that there is a risk of harm. With a 6-year-old, how do you know whether he knows the rules of gun safety? How do you know whether he knows even how to use the thing? What if he doesn't understand anything about trigger discipline and keeps his finger in there and suddenly goes to answer a question and pulls the trigger and shoots the person in front of him. All kinds of situations could result from him having a firearm that would produce deadly consequences. So, again, the fact that the manual says you have to let the administration know doesn't set the standard of care, but it certainly informs the standard of care. The adoption of a safety rule might show that the company, in this case the school district, recognized the danger, which again supports the foreseeability element in negligence. It may also be relevant as to whether the defendant's conduct was willful, wanton, or grossly negligent, or to show a corporate policy or culture of safety or lack thereof. In this case, I think it's lack thereof. And it can also be a part of what an expert considers when establishing their standard of care. But in this case, the expert can't consider it because she didn't get it before she wrote her report, and she is confined to the four corners of her report in offering her opinion. But generally speaking, an expert witness may rely on internal protocols, among other sources, to form an opinion about what a reasonably prudent actor would do. For example, in Riverside Hospital Incorporated versus Johnson, which is 272 Virginia 518, a 2006 case, the court allowed admission of orientation and training manuals not as the standard of care, but as part of the material the expert considered in formulating his opinion. Now, there is a distinction between public and industry regulations versus private, purely internal private rules. So, the policy manual inside the school is a private rule. It governs only the conduct within that school. That's what the staff handbook does. But if there is a state statute on point, if there is a state regulation on point, perhaps put out by the State Department of Education, or if the industry-wide education association has promulgated rules to that effect, those could potentially be admissible because they're not purely internal. They're not set by the defendant. And there's also something else that's worth mentioning. There is something called negligence per se. So if there is a statute that says an administrator must take notice of this and assume that it's a real threat until proven otherwise, well, then you would have something called negligence per se, which would be a topic of a completely different video. So that's how we have this issue in this case about essentially whether the policy manual can be used as evidence of the standard of care. Well, it's evidence of the standard of care, and the judge has said as much, but it is not the standard of care. It's simply one piece of that puzzle. And of course, the defendant is going to get up and testify that she considered everything and she didn't think the risk was real. She believed it had been invalidated by the fact that the teachers let them go outside. Again, the strategy here is to put the blame on everybody else and claim that you are as pure as the driven snow if you are the doctor in this case. So I thought I would clear that up. I thought maybe that might be helpful for people who are watching the trial and keep hearing this objection about the handbook. If you have any questions, drop them in the comments. I'll be happy to try and answer them. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.